So we're talking more about being in the dark and people complaining about their lawyers not explaining things to them. So let's like put this in a context, or we'll actually overview, and then we'll give like a specific example too. You need to know why you're doing things. And so if a complaint is being filed, if deposition notices are going out, there's certain witnesses being questioned, you need to know what's happening. You need to know why you're doing it. If there's a contract that's not a litigation, you need to understand the provisions, why they're in there, what it can do for you. And if you don't, you have a problem. And you have every right in the world to have it explained to you. If the answer you get is, well, I'm the lawyer and this is what we do, that's a horrendous answer. You're the client, you're the ultimate decision maker, and you're the person writing the checks. You have to know what's going on. So, but let's dig deeper. So that's like surface level, right? So let's go into it more deeply. In certain litigation cases that you can handle, there's an incredible stress and tension that can develop between the lawyer and client. Let me go back 20 years ago. So I'm first representing a client, and they were a very sophisticated client. I was in my late 20s, and it was a very significant case. They had worked with major law firms in New York most of their life, and they took a very, very, I was very grateful, took a huge liking to me, and were favorably comparing me to partners at internationally prominent law firms. But, right, this is a challenge. That client belonged to a country club. And at that country club, a lot of the people were asking him consistently, like, why are you having that guy, Sean Callagy, represent you? That's crazy. He's in his 20s. This is a multi-million-dollar case. What are you, out of your mind? And in the beginning, it was all okay. But then as time wore along, the client was getting more and more concerned. And I was much newer into the process. And again, this is 21 years ago. So I learned very early that the degree to which I would explain to my client what was going on would dissipate that anxiety, that fear that the client was feeling. So, for example, we filed this huge emergence motion in the very beginning of the case, and it was costly, and it was super involved. And I explained it, but I probably didn't explain it enough. So the client, we sort of won the motion, but not completely. But the purpose of the motion wasn't even necessarily to win the whole thing. The purpose of the motion was to make the other side take a position on an important issue. And the issue was we wanted to inspect and see if the computers were where they were supposed to be, and it was a massive amount of stuff to find. And the other side responded and lied in a variety of different ways, which was exactly what I expected and wanted. So the motion had massive value. But the client, when we were leaving court, was frustrated and upset. And so afterward, we had a very long meeting, and this was a transformative moment in my legal career, where I explained, I said, listen, let me go slow. I know I said it, but let me explain that the true purpose of that motion was to get this lie, that lie, and this lie. And a senior vice president swore under oath in written papers that this is what was. Isn't that a lie? Yep. Isn't that a lie? Yep. Isn't that a lie? Yep. And can we prove all three? Yep. And don't those lies matter? Yep. And so my explaining that to him changed the entire dynamic of the next 6 months, because we couldn't go right to their deposition. We wanted to do paper discovery first. There's relevance to doing it. And of course, you can't be exactly sure how the deposition is going to go. And I knew it was going to be real bad for them, but I quite candidly, I couldn't have imagined how bad it would ultimately be for them. So when it came time to have a deposition now, a lot of times when people prepare for depositions, there's like this sort of disconnect from the client. What should be happening in these situations is you should be sitting with your lawyer and talking and getting prepared for the dep. My client and I in that situation prepared 2 days, 2 full days for the deposition of an adversary. That's completely crazy. The case was worth millions of dollars, so the time was justified, and I certainly cared enough, and I wanted to be enlightened. I didn't want to be in the dark, and I wanted my client to be enlightened as to what we're doing. So we synergistically created this incredible plan for the deposition. And the byproduct of it was a senior vice president from a bank cried, I'm not joking, cried during his deposition. As I was asking him questions, in the morning I got him to admit he lied. I got him to withdraw his certification and say it was fabricated. It's perjury. He withdrew it. And then in the afternoon, we were asking him why he didn't call the court and tell him that he had lied, why he hadn't withdrawn his deposition during the lunch hour, and the guy actually started crying. The case settled 2 days later for $7 million, up from $100,000. If we don't prepare for that deposition together, because there was nuances to the lies that I wouldn't have kind of known unless we really thought about it, studied it, and kind of like peeled back the onion. But it was really that intimacy in the relationship with the client, and me being enlightened and him being enlightened, and that created a lifelong relationship. And that client, by the way, would eventually refer me lots of other work. We did other great things for them because they had such an appreciation for the fact that we cared enough to take the time to explain everything of why we were doing it. We never said, well, we're the attorneys. Because quite frankly, I think sometimes people say that because they don't even know why they're doing stuff. And if your lawyer doesn't know why they're doing stuff, that's crazy. So you have every right to hear from them why they're doing things. You need to know, because you need to know that they know. And there's a great distinction, I'll wrap up with this, that we talk about all the time. We say that, well, we've been involved in many cases where we'll tell our client, listen, our adversary is playing in the dirt. Like we talk about tiers of thinking. We'll say our adversary is playing in the dirt, right? And then maybe if they're a little bit more of a formidable adversary, we'll say they're playing checkers, right? They're playing checkers. They're playing ticky-tack little games. We're saying we're not only playing chess, we're playing like three-dimensional chess. And they don't even understand it. They think we're playing in the dirt like they are. Or they're playing checkers and they think we're in the dirt. We're playing three-dimensional chess. And then we don't just say it. We'll say, because they had a deposition where they didn't even understand. One of the top 100 national jury verdicts that I achieved, when I was done examining a witness, and my adversary in that case was a very prominent attorney, trial attorney, former U.S. attorney, very prominent. When I was done examining the first witness, and my client knew exactly what I was doing, so we're on the same page, the other side, formidable, many-year U.S. attorney, high-profile cases, television, had been on television, he was high-fiving his partner when I was done. And inside I was laughing because he was playing in the dirt. He had no idea what just happened and when I was going to do that testimony. And I actually elicited testimony that was truthful and unfavorable from a neutral witness to boost his credibility and to establish credibility on 2 points I would later destroy them with, and they never saw it coming. And then a few days later, they were begging me to settle the case, saying, you're going to ruin somebody's life. They really didn't do it, which was complete nonsense, right? But they now knew that they were like the rabbit boiling in the water. And all of a sudden, it was too hot, and they were done. And that's what comes from really informing your client informing you, and you both enlightening each other, but caring enough to do all that, being urgent and aggressive enough to do all that. And I could tell you stories all day long, but that's how the legal profession truly works. Liars get theirs in the end, but only if, right, people are communicating and know what's going on. And the only way the client, you, is not filled with anxiety and fear and concern is to understand consistently why we're doing what we're doing, why these things are happening, why they're getting bills. And because, listen, there's a lot of good work that goes on for people by lawyers. But they get a big bill, and they didn't get copies of the work. They didn't get drafts. They have no idea what in the name of God is going on and why these bills are happening. And that's really a failure of communication. And that's on our part as the lawyers. And, so it's on us. And if you're not getting that, give us a call, right? If you have a legal problem and you want that type of communication, please, I'm Sean Callagy. Would love to help you out and show our caring, urgency, aggression, keep you enlightened and not in the dark. Please give us a call. Thank you.